I do appreciate your contacting me. You, my listener, if you have something for me to see, then you need to let me know. We are here at Nooga Radio, and we believe that you report and the world decides. That is the, I think that is a proper argument to make, a proper proposal in a world where everyone just about has a smartphone that has a very fine camera, that has a recording device. And what we would be grateful to hear from you regarding would be your encounters with the good people. So if they're good people whom you encounter, especially on the side of the street, let us know and send us the link or send us the raw file. We'd love to hear from you. And I made a point yesterday that it makes me think I said too much, and that is that our police departments in the Chattanooga area generally are pacific and mild, and I attribute that to God's blessing to this city. That it is true that there is generally mildness by the officers of the department run for 3 years or so by Fred Fletcher, now headed by the new chief of police, and then also in the cities around us, there are few reports of police abuse that we are seeing from around the country that are adding public sentiment, adding public grievance against the very idea of policing. Right, that as the state disintegrates, the idea of policing will disintegrate with it, and it will be in the decades ahead entirely disappear. I think policing will entirely disappear as the state runs out of steam finally and fails as a concept, and people have other things to worship perhaps in the future, as many will continue to make the mistake of rejecting God and having to have some human invention or human idol to bow before. Well, this is David Tulis, and the idea that policing is mild in the area comes because I've not been sent any videos of a violent encounter. And so I say, well, if you have one, let me see it. I'd like to know about your ordeal. And I always appreciate hearing from listeners and from members of the public who have something to say. That's how we met Hanson Melvin. He called me and said, David, I've got a remarkable story to tell you. And he had my full attention for the whole afternoon as I got that story about his false arrest and him being a victim of police perjury here in Chattanooga. So this is part of my job, is to tell your story on the David Tulis Show, and of course at our chief sponsor, Nooganomics.com, which gave exhaustive coverage of the Gelpin arrest and the Hanson Melvin arrest, of course, and the vindication. And now, of course, Hanson is suing the city and former Officer David Campbell for abuse and kidnapping and harassment. But generally, though, on the whole, even though we have an occasional police execution, there is much to say in favor of that here, and the mildness, the relative mildness compared to other cities. And now there's a mildness in Washington that I want to mention to you that's, I'd say, is significant. And it is from the director of the Environmental Protection Agency, E. Scott Pruitt. And this came to me from a man who works in the city. And I said, have you seen this? And of course, when someone sends me something like that, I always give it my full attention. And indeed, I did. It is a letter to his department about what we're going to do now. We're not going to allow private parties to own the government. We're going to have open government as much as we can. And I'm going to resort to the UAPA, the Uniform Administrative Procedures Act, which is, you could say, the basis of the secret state, the surveillance state is in UAPA. It is an administrative law, right? The whole administrative realm is its own universe. It is a vast world of courts and pleadings and controls and adjudications, where nothing is adjudicated. Well, really, it's not adjudication. Nothing's adjudicated. It's all administered. You have administrative courts that operate in terms of the UAPA and the statute and the regulations. And people, they can have a whole process, a whole civil, even criminal process, not criminal, but civil processes, court processes in agency, right? I in fact had such an ordeal in the early 2000s in the Department of Safety and Homeland Security. A case that went in agency, and my My enemy. This was in the enemy's field, and the whole thing was done in the enemy's court, if you will. And there was no jury trial on findings of fact, right? There was no jury available to me because all the findings of fact were in agency, and that was the basis of the appeal. The record went up to Chancery and on up to the Court of Appeals. The facts already having been decided and found by the agency itself, right? The agency against whom I was fighting. So you have an extra constitutional realm there that Dr. Hamburger, I think from Princeton, warns about as perhaps the greatest threat to liberty, because it's all arbitrary. It pretends not to be arbitrary. It pretends, that whole realm pretends to follow statute and regulation written by, of course, the executive branches, right? The executive branches write the enabling rules that let the statute written by the Congress live and breathe, right? The Congress has the statute, which is general, and the agencies write the specific rules that then control its actions. And there's where you have a lot of gray areas. Now, Scott Pruitt, a Trump appointee, has a letter, and it's a remarkable letter in that it brings up the whole idea of federalism, which is to say relations among the 50 republics and the central power in Washington. And it is in favor of federalism, in favor of divided government, and makes extensive use of the founding ideals of the country. And that would be three-part government, that being the legislative branch, the executive branch. Of course, legislative branch is Congress in Washington. The executive branch is the presidency, under whom all the agencies work, right? All agencies, including the IRS, are executive agencies. It works the same in Chattanooga. We have city government with its three parts. Policing, for example, is part of Mayor Andy Burke's government in the executive branch. And all the agencies are. And then with the city council or the Congress in Washington make the laws or the ordinances. And then you have the judiciary in Washington. Of course, you have the Supreme Court and the U.S. District Court in the districts. There's a Court of Appeal, mid-level appellate courts. In the city, you have city court, right? If you have a grievance in city court, which has authority over ordinances, you can petition for a trial de novo in circuit, right? A brand new trial, not an appeal, but you can have a brand new trial in circuit. But that court handles some criminal matters as well. So we have that division throughout the American system. And though it's soundly abused, and generally, I'd say generally we have in the American realm of law, we have the supremacy of the executive. That's what administrative law in the end is. It's the executive branch does what it will, or President Trump will do what he will, or Obama will do what he will, and it's all executive. And the problem with that is that the other branches, the other branches kind of wither up. Congress is largely withered up. It does not assert itself. It does not bring about reforms. It does not represent the people at all anymore. And the judicial branch, though it tries to make a name for itself. Look at the queer opinion of Obergefell versus Hodges. That pro-Poofter decision pretended to eliminate marriage in all the states and create a kind of a hybrid system. It pretends to have eviscerated all marital statutes across the country and all marital constitutional provisions across the country, and imposed instead an egalitarian nullity, a non-law that Jeff Atherton, the Chancery Court judge here, has rightly complained about. How can you do anything when your statute has been emptied of all its meaning by this opinion? Right? That's what he's asking in one of his rulings in I think a divorce case. So Scott Pruitt says that his grievance is in upholding federalism and upholding the rule of law and the three parts of government is in the area of what's called consent decrees. Now, Chattanooga is under a consent decree as well on its stormwater wastewater output under the EPA. But Scott Pruitt says we need to stop. In fact, he terminates that form of regulation. He says the days of this regulation through litigation are terminated. Consent decrees are about consent. Okay, where does this consent take place? Well, it takes place in courts. And what happens is environmental agencies and private parties or corporate parties sue, and sometimes there is complicity with the EPA. We have a lawsuit, and then a judge orders how the agency is to act in the area of the lawsuit. So you have a consent among the parties that this is what we're going to do. This is how the law is going to be applied in this case. And the whole thing is overseen not by the EPA, and its regulators, who are scientists and specialists in pollution and infrastructure. It's not run by them. It's run by a court, and that is what's going to end, according to Scott Pruitt, the administrator. And it's a letter dated October the 16th. And thank you, my listener, for passing that on to me. And I do want you, my listener, to know that you can always contact me through Nooganomics.com and send me anything you want. You can also contact me here at the station. We're live on Facebook. You can message me through Facebook. That might be the easiest way. And that's at Nooga Radio. We're live on Nooga Radio on Facebook, and that might be a convenient way to hear our show. Of course, we have a website, which is Noogaradio.com. That site's just a bread and butter site, and its main job is just to play the audio. And you can hear it anywhere in the world, or anywhere if you're passing beyond the range of our powerful digital signal, which is 95.3 HD4. By the way, do tune into that. That reaches out 60 miles. Powerful signal. All new cars have HD, which is a high definition, 95.3 HD4. And on our regular, ordinary and routine, but very happy, very, very happy 92.7 band on FM. And also, of course, on Facebook. Again, Facebook, Nooga Radio. Live there, you can see if my bow tie's okay. I pull the camera screen a bit back. You can actually see my bobbing Adam's apple. Sorry. I know women don't understand Adam's apples at all. They don't understand them. And so when a tie bobs a bit when a man talks, that's a cause of concern. But my bow tie is red. Now, the letter says, for example, let me just give you a little an explanation of what he's talking about here. I think it's important because it shows that President Trump does have in view getting men and women in his administration, which understand American government and believe in the way it works. Because after all, administrative law is supposed to make government open, right? It's supposed to make government accountable. And that's what E. Scott Pruitt wants. He wants accountability. Sue and settle, as this tactic has been called, undermines, he says, the fundamental principles of government that I outlined on my first day. The importance of process, 1, and 2, adherence to the rule of law, and 3, the applicability of cooperative federalism. Of course, that cooperative federalism is where the states and the federal government work together, and not by a top-down method or a sidestep method where the federal court rules on an EPA rule in a particular area, right? That confuses government, as he'll go on to say. The process by which EPA adopts regulations sends an important message to the public, and that is EPA values the comments that it receives from the public and strives to make informed decisions on regulations that impact the lives and livelihoods of the American people. The rule of law requires EPA to act only within the confines of the statutory authority conferred to the agency. How about that? And thereby avoid the uncertainty of litigation and ultimately achieve better outcomes. He says EPA must honor the vital role of the states in protecting the public health and welfare under the principle of cooperative federalism as prescribed by the Constitution and statutory mandates. He says if an agency agrees to resolve litigation through a consent decree or settlement agreement, however, questions will necessarily arise about the propriety of the government's determination not to defend the underlying regulation or decision. Indeed, sue and settle has been adopted to resolve lawsuits through consent decrees in a way that bound the agency to judicially enforceable actions and timelines that curtailed careful agency consideration. This violates due process, he says, the rule of law, and cooperative federalism. EPA risks bypassing, he says, the transparency and due process safeguards enshrined in the Administrative Procedures Act and other statutes when it uses a consent decree or settlement agreement to bind the agency to proceed with a rulemaking with a certain end in mind on a schedule negotiated by the litigants. So you see, you have these private parties sort of setting the agenda of the agency and controlling part of its operation. And he wants that to be, he's actually said it's ending. He said it is ending. Following the legal processes for agency action provides predictability for all stakeholders, ensures, he says, that the agency will receive input from all interested parties, not just the people who are suing, right? And increases the defensibility of an action when facing a procedural challenge. The number is 800-8949, 800-8949. And here I mark this as I marked. You know, when I go through something, I read it very carefully, and I put marginalia. I write comments in the margin. And here, this is what I say is good. Even when an agency attempts to comply with these procedural safeguards in these agreements, the agency typically agrees to an expedited rulemaking process that can inhibit meaningful public participation. This rushed rulemaking process, he says, can lead to technical errors by the agency, insufficient time for stakeholders to submit rigorous studies that assess the proposal, the inability of the agency to provide meaningful consideration of all the evidence submitted to the agency, a lack of time for the agency to reconsider its initial proposal and issue a revised version, and the failure to take into account the full range of potential issues related to the proposed rule. So he wants there to be public input, and he wants that public input to be counted as something that's important. And so if you're in an industry or business and you want to have input on something that affects your field, you should be able to have time to have it and not have that whole process short-circuited by a lawsuit from an environmental organization. The greatest evil of government by consent decree, he's citing here a 1983 court ruling, comes from its potential to freeze the regulatory processes of representative democracy. At best, even with the most principled and fair-minded courts, the device adds friction. As a policy device, then, government by consent decree serves no necessary end. It opens the door to unforeseeable mischief. It degrades the institutions of representative democracy and augments the power of special interest groups. It does all this in a society that hardly needs new devices that emasculate representative democracy and strengthen the power of special interests. Of course, we don't have a representative democracy. We have a democratic republic. There is a difference. And the judge in this, who wrote this decision, or these lines in this decision from 1983, the U.S. in the District Circuit Court, Citizens for Better Environmental versus Gorsuch, he doesn't really seem to know the difference. But on the other hand, I would say that this ruling is a defense of the executive branch. And what he's doing is he's saying, well, we don't want the judicial branch messing with our executive prerogative. So in a way, this discussion that quotes James Madison a good bit is right, but on the other hand, it serves the end of the executive branch, and that's our problem in this country. Is we have executive government. That executive government is another term. You might say kind of another dull academic term for tyranny, but tyranny occurs when there are executive people acting outside of their authority, outside of constitutional authority, and they execute things, right? They demand that things happen, they order things to happen, they ordain things to happen. That is executive, right? You execute something, and that's what that branch does. That's why it's the leading branch. It is the leading branch. James Madison says, no political truth is certainly of greater intrinsic value or is stamped with the authority of more enlightened patrons of liberty than that on which the objection is founded. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. And that's the EPA administrator quoting James Madison in the Federalist number 47. Were the federal constitution therefore really chargeable with this accumulation of power, or with a mixture of powers having a dangerous tendency to such an accumulation, no further arguments would be necessary to inspire a universal reprobation of the system. Of course, reprobation simply means a condemnation. In other words, if our system of government allowed there to be a mixture of powers or an accumulation of powers in one branch, then that would be worth reprobation, worth condemning. And that's what, of course, James Madison is doing. But because we've had a total state, we've had a nuclear state, a military warfare state now for many decades, one that is in decline, right? And we need to see that it's in decline, and we need to see it as a favorable development to us here in Chattanooga, because the national state is in declension and because it is in bankruptcy. It is effectively bankrupt. We have the prospect of devolution and the return of power to us. Now, in Catalonia, there's big news this morning about a proposal by the Independence Party for everybody to get their money out of the banks. That poses a monetary financial crisis to the central banking system of Spain, which of course is highly leveraged, saddled with bad debt. It's just choking with bad debt. And so people are drawing cash out of the ATMs. Millions of people drawing small amounts. That could just ruin. And that's kind of one of the arguments I make on Cash Friday, the first Friday of every month, where we draw out from the bank green rectangles like these I'm holding in my formerly ink print stained fingertips. $100 bills. I've got two here, two $100 bills. Important. David.
The Tennessee Valley's news talk leader. Nooga Radio. Digital FM 95.3 HD4 and